So maybe just a couple of follow-up questions based on those comments. The first is maybe to ask Olivier, just this issue of timing and sequencing has come up a lot, and I think Mali is a fascinating example of that, because we're at the beginnings of a transitional justice process in Mali, with prosecution of a former coup leader, arrests of former Islamists, and yet the peace process in Mali is really ongoing and is not even close to finishing. So what do you think is going on in Mali now? Is it good sequencing, bad sequencing? Betsy talked again about the sort of relationship between transitional justice and governments. And particularly if we think about international justice and courts, we're starting to see people talking about international justice and its relation to national governments through this concept of positive complementarity, and trying to use international justice to nurture and promote national justice. And so my question is sort of, how is that going? And can we all think of examples where that has worked or hasn't worked? And I'm sure Andrew would have comments on that too.
Yeah, thanks, Jim. As to a good or bad sequencing in Mali, I think I'll perhaps try to bring a situation where people thought 10 years ago that there could be a good sequencing to have a framework where there will be a plan to first have a soft transitional justice mechanism, referred to often as a truth commission, and then later on prosecute people after the TJ process, after the prosecution will have taken root, and that's Burundi. There has been an agreement to end the conflict in Burundi in 2010. It has been like now, we have 14 years that there is a concept, at least a framework to address this issue. It was like first have a truth commission, then we prosecute. 10 years down the line, we have not seen a truth commission in place, nor prosecutions. So that sequencing that was very good in paper, in fact, or in practice, it produced absolutely nothing. Even the situation went from good to bad or to worse, so to speak. So in Mali, I think the problem is that, and I think in Mali, as in Burundi, the question now will be about the credibility of transitional justice. We may be a little bit a joke when we propose transitional justice if it starts becoming like it's a way of keeping people calm or buying time and then in the end do nothing. In Mali, it's very difficult to actually talk about a careful strategy to address mass atrocities and handle the victims at the same time, because, first of all, the conflict is not totally finished. The conflict is not totally finished. In the north, peace negotiations have not taken place, and people that are interlocutors for peace now are people on whom there are serious allegations of human rights violations. So for them, clearly, there will be no desire for truth commission, no desire for the truth, or no desire for punishment, except from the victim perspectives. So the challenge then will be how to put a victim-centered agenda in a peace process where interlocutors from both sides, government and rebel groups, are part of the problem. And this actually dictates a sort of actually non-sequencing in the end, because it's very difficult to plan absolutely nothing. But I think the way maybe to go about that practically is to perhaps try to make the victims play a very important role, because victims from government side or from rebel side are just victims, and what they are interested in is to get some kind of recourse, to get some kind of dignity, and that will be quite interesting. As for the coup leader Sanogo that is being prosecuted, that's quite a very good development for the rule of law, and could be a very good example for transitional justice if the process of bringing to account such a high-profile person who has committed atrocities will be done properly. And if Mali is not able to prosecute Sanogo properly, not respecting the rule of law in the proceedings, it will just cast a doubt as to the the Malian state capacity to actually prosecute complex crimes, including the destruction of monuments in Timbuktu, which are far complex international crimes. So, but I guess for now on, there is absolutely no sequencing, and the bad or the side effect or the flip side of not having sequencing will be perhaps how do you, in the end or at a later stage, still talk about transitional justice and maintain a certain credibility on the product you're selling. Because for more people now, it's like a transitional justice become a sort of concept to actually talk about the problem and not do anything concrete on it.
Thank you. Andrew, any comments on the international justice and its relationship to governments now through positive complementarity?
Sure. Just when I got into this, I actually was all about international justice and the tribunals. I thought that was the magic bullet that was going to do it, in Bosnia, Rwanda, elsewhere. And I don't think it has yet, right? It's still a work in progress. So I'm glad Betsy raised the issue of positive complementarity, because I understand that we have two systems in place here. We have at the international level and at the national level. And it's the norm of international law that we know the primary responsibility for protecting and promoting human rights is at the national level, and also in investigating and prosecuting those violations also at the national level. And where states are unable or unwilling to undertake that charge, that's when the international complementary mechanism kicks in. And under positive complementarity, which I think comes out of the Assembly of State Parties of the ICC Rome Statute, there's this role for the international community, and this brings in the rule of law that Betsy was talking about, to sort of buttress that ability to participate in that complementarity regime. I would say transitional justice at the national level is also a gap filler. And this gives me an opportunity to talk about how some people refer to transitional justice as a special form of justice. Why aren't you just using the existing system that's there, particularly on the accountability side? But as we know, the system is often, and there is criteria under the jurisprudence of the tribunals on what is unable or unwilling, I think. So, but often the system doesn't exist, it's been destroyed, or it's just unable to deal with the nature and scope of mass atrocities where you have thousands of victims and thousands of perpetrators. So these transitional justice mechanisms, whether they're a special tribunal such as within the International Crimes Division of Uganda, of the Supreme Court, or the special panels of Timor-Leste, are there to really begin addressing this from an accountability standpoint. And then the truth commissions come in to deal with sort of the larger group of victims. So there is something of a tension there. I wouldn't say transitional justice is a special form, particularly if we abide by due process standards and make sure that there are protections for all of the people included. I think the other thing I would just say in terms of tensions, we can see this in the context of the interaction of international and national justice. So in the case of ICTY, there were many cases that were brought and to be prosecuted at the ICTY. And there were arrangements to transfer some of those cases to national jurisdictions. In Bosnia, the state court of BIH, for instance. And at the same time, the state court had its own investigations and prosecutions. What you see happening now in Bosnia, maybe people know this better than I, but a lot of those cases that are moving down the chain, where we say justice is really supposed to happen, from the international to the state court's actually transferring thousands of war crimes cases down to the lower courts of Bosnia and Herzegovina, cases that already lack capacity and have massive backlogs. So this is, I think, important to think about from a rule of law perspective and a transitional justice, because a lot of emphasis in Bosnia is on transitional justice. It's because it's political, and the diplomatic push is try these cases, get these bad guys. But then you see the implications for rule of law. Same thing on the victim side. There's lots of attention to providing services to the victims of war crimes and SGBV in conflict contexts. But then we have to look at what about the general victims of crime in a country. So I think that's another tension, which I may have gone off point. But.
No, thank you. Betsy, any comments on the complementarity?
Just one quick add-on to Andrew's last point is not only can transitional justice cases overload a domestic system, but can leach a disproportionate amount of resources to a special court that might better be allocated to a general rule of law program. So they're very difficult choices to be made there.